The expert witness for domestic violence, and I don't know how to pronounce it, Kit, K-I-T, last name G-R-U-E-L-L-E.
All right.
And the accident reconstruction analysis, and I'm not sure which witness
Your intention to call the LLE?
Yeah, Kit Gruel and the accident reconstruction, actually both of them, and it would be Charles Manning III, because unfortunately the dad, who was originally the one who was going to do it, was not available this week.
All right. Okay, well tell me about, if you just give me a forecast of the evidence what each of these two will testify to, and then let me hear the basis of the objection.
Okay. Well, for Ms. Gruel, she's a domestic violence advocate, trainer, consultant. She works with law enforcement. She works a lot with victims. She's been doing this for years, and she's largely going to testify to, women who have had a history of abuse, had a history of domestic violence, or even in these traumatic situations, kind of how their reactions come, how sometimes they get a little confused in the facts, and just kind of the appropriate reactions in the training of how they react in domestic violence situations or when they are threatened. And so she's going to kind of testify a little bit to Crystal's background and how she fits that profile and how that helped dictate her reactions and what was going on here.
All right. Ms. Franks, what's the basis of your objection here?
Your Honor, we basically objected to the report that we were given to her conclusions. The state would argue that these conclusions are not admissible as opinions from a domestic violence expert.
Could I have a copy of that report?
Yeah, Your Honor.
We have no problem if she wants to get up there and talk about domestic violence, the difference between victims and predators, the cycle of domestic violence, and give an opinion as to victim, predator, or cycle of domestic violence. However, her conclusions have nothing to do with her opinion. They go to intent, which is an element of the crime and a fact finder for the jury. Matter of fact, all of them go toward that. She's basically saying how she feels Crystal responded, why she responded, and that she didn't have the intent. But she's not qualified. No domestic violence experts qualified to testify as to intent or what was going through the victim's mind or the defendant's mind at that particular time, which is basically the report, what the conclusions are. It's basically trying to explain away Crystal's actions or inactions as to intent, malice, or feelings, so forth. And the state would argue a domestic violence expert cannot testify as to an opinion as to those things.
All right, let me just finish reading the conclusions here. All right, Mr. Meyer.
I would point out Rule 704. It specifically says testimony in the form of an opinion or inference is not objectionable simply because it embraces an ultimate issue to be decided by the trier of fact. And her conclusions are relevant based on her experience and having done this. And obviously, we can, have her go into her experience to see if you believe she's qualified. But Rule 704 speaks directly on point to her conclusions being, something that embraces the ultimate issue to be decided by the trier of fact.
Rule 702. Well, she nonetheless has to be qualified to give an opinion as to someone's intent, and that, I think that may be what I understand the gist of the state's objection is that no one is qualified to give an opinion as to intent when there's not some direct evidence of that.
And Your Honor, our conclusions are not opinions, are expressed as opinions. And when you take into account this coming in along with Rule 403, it's more prejudicial to the state than probative to allow this type of testimony in. Again, it's not expressed as an opinion or an inference. It's basically rehashing how she thinks Crystal feels over these particular circumstances, which would go to her intent. And a domestic violence expert is not qualified to talk about intent.
And Your Honor, if it was one where you wanted to limit it to us discussing domestic violence, how people in general tend to react to these things, and not have her go into the specific intent, we're okay with that.
All right, I'm looking at the conclusion page. And the first two conclusions seem to be opinions about how domestic violence generally affects women who suffer those types of relationships, and that, in her opinion, Ms. Mangum's behavior was consistent with that typical reaction. I call it typical of someone who is involved in such an abusive relationship. So it seems to me that to the extent that this expert is proposing to render opinions that Ms. Mangum was involved in or had a history of abusive relationships, and that typical symptoms of women who are involved in abusive relationships are certain symptoms that she describes here, how they respond to threats or quickly assess threats, things of those sort. Those would be, and I'm not making a ruling, but I'm rather thinking out loud, and then I'll hear from both of you again. Those seem to be expert opinions that may be within the scope of her expertise and competent. Then further, an opinion that the events that, or the sequence of events that was described to her by Ms. Mangum as it escalated throughout that evening is also consistent with the symptoms that she has observed or studied with respect to battered or abused women. I think that's also a competent opinion that would be admissible under Rule 702. Going beyond that into what Ms. Mangum thought or felt or intended that evening, I think, would be outside the scope of her expertise, but rather, and that's different from the symptoms. I'm analogizing this to both of you, I'm sure, have tried or defended cases involving child sexual abuse, and where there's no physical manifestation of it, but rather an expert can testify as to the typical response of children who undergo that sort of trauma, and whether the actions of the child were consistent with what would be typically found. I think that's the analogy that I'm drawing here, and I think that would be permissible under Rule 702, whether the reactions that were described to her in compiling this report that she bases her opinion on are consistent with what, in her opinion, one would find with abused or battered women. I believe that would all be within the scope of Rule 702. So, Ms. Franks, let me hear your view on that scope of opinions from this expert.
The state has no problem with the scope of those two opinions. However, the state has problems with the way she's worded it in her conclusions. It's not worded as an opinion of typical. She's basically saying how Crystal reacted and what Crystal's feelings and what's going through Crystal's head. If she phrases it the correct way, the state does not have a problem with those two opinions coming in.
Right, and I agree that the way it's written, the first two, the first one, I think she can render an opinion as to whether based on the history that was recounted to her, Ms. Mangum has been in a series of what this expert would characterize as abusive relationships. I think that's an opinion she can render. Then she can also render an opinion about typical responses of women who have been in abusive relationships. For example, that they may be more quick to assess a threat, respond more quickly. And then she can render an opinion that what was described to her as occurring that night by Ms. Mangum is consistent with, or not consistent with, whatever her opinion is, consistent with typical behavior exhibited by women who are in abusive relationships. I think those questions would be competent, but to say that Ms. Mangum did something specifically because of, for some reason, that goes to a person's intent, which I don't think this witness, and perhaps no witness, is able to render an opinion on other than through direct evidence. So is that scope fairly clear?
Yeah, that scope is clear with me. Obviously, the only thing I'm going to ask is if I can have a few minutes to make sure I confer with her.
And let me just check, Ms. Franks, is that the questions or the scope of the competent evidence that I've described, is that something the state would continue to object to?
No, Your Honor, as long as it followed that type of scope and that type of wording and opinion, the state does not have a problem with that.
All right. And we'll, obviously, if there are concerns as the questions are posed, or if the answer is straight outside the scope of the questions, then make your objections and I'll deal with them as we go along.
Okay.
All right. Let's talk about, is it Dr. Manning or Mr. Manning the third?
Let me double check the third. Junior, his dad's a doctor. He is just Mr. He's only got a master's.
All right. So let's talk about what the forecast of evidence from Mr. Manning is then.
And the forecast of evidence from them, Your Honor, is, and they actually have some pictures and a video, which I'll eventually need to get set up if we can go with them, is essentially they did a reconstruction on the force necessary to kick the door down as it was done to show and demonstrate, we had some of the testimony that, they're weak doors or they're this, that this is going to demonstrate the actual force required to have knocked the door off, to have knocked the similar door off its frame. And that's going to be their forecast of evidence, and they have some video demonstrations, both of a weight knocking it in and of it just being yanked off, to demonstrate and generate their report as to the force that was actually required to produce the damage that has been shown in all of the pictures and that Mr. Day has admitted to causing.
Ms. Franks?
Your Honor, the evidence at this point is conflicted. Mr. Day admitted to kicking a bathroom door in. He didn't say which one. And the defendant even said it was the one in the bedroom, not the one in the hall room. In any event, all of this is an accident reconstruction, and it's dealing with Mr. Day's weight. But as to their report, they basically say that any of their tests, it would all depend on the strength of the door material, the construction's material, the quality over time, the condition, age, as well as the original manufacturer. They don't have any of that.
Could I see the report?
Yes.
And basically, Your Honor, the state's argument is that all of their tests are based on something that they went and got after looking at an apartment that is currently available for rent.
Not the actual door frame.
They never saw the actual door frame, or anything. They may have seen pictures, so they don't know the quality of construction, the condition it was in prior to it coming off the frame, or anything as to that nature, or even who, at this point, took it off the frame. And based on that, the state would ask that this not be allowed under 403. It's more prejudicial and confusing on the issues than pertinent.
Mr. Meyer?
I mean, that is what accident reconstruction is. They had, the neighbor, they had Carlos Wilson testify about how weak his doors were. They did go to the site, they talked with the maintenance man, they studied the nail patterns, they made sure they used similar construction and everything else to put that frame together. No, they didn't have the original door to inspect or do anything else because the police failed to ever collect any of that evidence. And that, for a variety of reasons, the police didn't do anything with the original door. They went to the same apartment complex, they talked to the same maintenance man that Ms. Franks talked to and asked about the strength of the doors, how they were constructed. And he gave them the information, showed them and said, look, that door is basically the same as this. They're all the same. We don't have that door, but it is what it is. And so that's what they based it on. Obviously, it wasn't the exact door. That's gone. We don't know if the police ever collected or what they did with it.
All right. Let me take a moment to look at the pictures that have been introduced into evidence, particularly the pictures from the apartment that would show that door.
Yes.
If you can find those for me out of the stack of evidence that's been previously admitted.
Mayor Pro Tem?
Yes, please.
I believe that's any that show any part of
All right, so I'm just reviewing for the record. Exhibit 77, 102, 104, 103, 84, 85, 83. All right, either of you wish to be heard further on this,
not the statement.
Mr. Meyer?
No.
All right, I'm going to exclude the evidence of regarding the force necessary to open a door as set out in the report of Accident Reconstruction Analysis, Inc., both on the basis of Rule 702 of the Rules of Evidence regarding the relevancy of opening a door other than the one that was in the apartment on that night, specifically because we've heard testimony about various variables that would affect the force necessary to open that door, and so the reliability, I think, is problematic, but it also would tend, in my view, therefore, to be speculative in the accident reconstruction. Also, under Rule 403, I would find that the evidence is not particularly helpful to the jury. They have information before them from which they can evaluate the facts of this case. And then finally, under Rule 403, I would find that the evidence could tend to be confusing. So for all of those reasons, both under Rule 702 and under Rule 403, finding that the probative value is outweighed by the potential prejudice of allowing in, I'm going to exclude the expert opinion regarding the force necessary to open the door.
And Your Honor, I would just ask if at the appropriate time we can go ahead and just make a proffer
Yes.
Of that for the record.
That'll be fine.
The video and the report.
All right. Well, we can do it just that way if you wish. I mean, if you don't need your expert to testify on the record and you just wish to submit the report and the video, then of course I can accept that as your proffer. If you want to call your witness to make a brief proffer, I can allow that.
I'd like to at least have him make a brief proffer because, I mean, unfortunately the Court of Appeals sometimes has their own opinions on what we should do.
All right. What I'm going to do then is we'll do that at the next break rather than keep the jury waiting for that. We'll go ahead and take that up at the next break and make that part of the record.
Okay.
All right. Anything further that we need to take up outside the presence of the jury?
Not the statement.
No, other than I just need a few minutes to talk to my
Yes.
expert about limiting the scope of what she's got.
All right, that'll be fine.
Okay.
So if you want to take 5 minutes, if you need more, just let me know. Just come back in whenever you're ready.
Okay, thank you.
Ready to proceed. It's not from that here. Sign this continuance. What's the?
Your Honor, I don't know if you want to do it at this time or a later time. We had earlier in the week, or earlier in the trial, an issue with an expert that we are now not going to call. But since there was the discussion with my client who originally wanted that expert called, I don't know if you want to hear from her on the record that she's now okay with it not being called. I don't know if you want to do it now or wait.
We can go ahead and do that now, so that's fine. So, and what was the name of that expert?
Dr. Christina Roberts, Your Honor. We did generate the report, we did produce the report, but have since decided we are not going to call her.
Okay, so Ms. Mangum, let me have a brief conversation with you about that. You'll recall earlier in this trial I asked you about essentially a disagreement as to strategy that you were having with your lawyer regarding the calling of a doctor, and I instructed your lawyer that based on your wishes, he was to have that report prepared and to make that witness available. Have you and he now discussed this matter further, and he's indicated to me that it is not the defense's intention to call that expert. Do you agree with that strategy at this point, ma'am?
I haven't been given a whole lot of time to consider.
We can address it after the next break.
All right. We will address it again, and that's the question I'm going to need you to answer for me as to whether you are now in agreement with that strategic decision not to call this witness, or whether it is still your desire to have that witness called and that you would so instruct your attorney to do that. That's what I need to know the answer to. And why don't you take the time to talk about it with your counsel, and then we'll raise it at a later time. All right? Very good. All right, anything else that we need to take up outside the presence of the jury?
Not for the state, no.
Not for the defense, Your Honor.
Let's go ahead then and bring the jurors back in. All right, ladies and gentlemen, thank you for your patience. There were some matters I need to take up outside the presence of the jury, and again, I instruct you not to concern yourself or speculate as to the nature of those matters. Mr. Myers, further evidence for the defense?
Yes, Your Honor. We call Kit Gruelle to the stand.
Place your left arm above and raise your right, please. Do you solemnly swear the testimony you shall give the court in the case now being heard shall be the truth, the whole truth, and nothing but the truth, so help you God? Please have a seat.
Mr. Meyer?
Good afternoon, Ms. Gruelle. Could you please tell the jury and the court reporter your full name, and could you please spell it for the record?
My first name is Kit, K-I-T, last name Gruelle, G-R-U-E-L-L-E.
Okay. And where do you currently reside, Ms. Gruelle?
I reside in Haywood County, North Carolina.
And how are you currently employed?
I am self-employed. I do contract work for the state of California, training law enforcement officers, in particular hostage negotiators. I do work on individual domestic violence cases, and I'm finishing up a film on violence against women.
Okay. Can you please describe your educational background for the jury?
Sure. I have a bachelor's degree in sociology from Appalachian State, which I just completed last year. But previous to that, I have spent about 28 years working in the domestic violence movement. So I've got about 50,000 plus hours working with victims of domestic violence.
Okay. Other than your education background, what kind of training have you received?
When I first became an advocate, I attended any and all trainings I could. At the time, there really wasn't that much, but over the years, particularly in the 90s, things started to really change. So after the passage of the Violence Against Women Act, I had opportunities to attend the National College of District Attorneys conferences on domestic violence, which were multidisciplinary conferences that included law enforcement, prosecutors, advocates, and other allied professionals who worked with victims of domestic violence. And then in '97, I was asked to come and start to work with the state of California to train law enforcement out there. And so I worked with all their first responders, including public safety dispatch. And I've also, I guest lectured at all the local law schools. At the medical school, I taught a class for all the first year medical students for 21 years. So I've gone through lots of training. But I've also, over the years, because of kind of being in the trenches and seeing how domestic violence plays out and who interacts with domestic violence victims, that there was room for many people to get involved. And so I got busy kind of building those relationships, which led to ultimately me running a program in Chatham County called the Bridges Program, which is what's called a coordinated criminal response to domestic violence.
Okay. Have you worked with any of the local women's domestic violence shelters in this area?
I started the Orange Dome Coalition for Battered Women, and then worked briefly at Interact in Wake County. I worked there only for 3 months because my son was paralyzed, and so I left work for a period of time. And then when I went back to work, I had been in Chatham, gone to Wake County, and then I went back to Chatham, and so I spent the majority of my years as an advocate working at the Chatham County program.
Okay. Can you describe what does the Chatham County program do? What does an advocate do?
What we do is we stand alongside victims of domestic violence and sexual assault. We're there to provide them with support, with encouragement, with access to resources, whether that's shelter, whether that's assistance in civil court with restraining orders. So we're just kind of there to be with them as they try to navigate these various systems and services that they need to navigate.
And what about this Bridges program?
The Bridges program was one of the first coordinated community response programs in the state. And what we did with the Bridges program, or what I did with the Bridges program, was we brought together everyone who potentially interacts with victims of domestic violence and sexual assault. So that was the prosecutor's office, that was law enforcement, that was mental health, it was the schools, it was kind of anyone and everyone who had a place at the table in dealing with domestic violence and sexual assault victims.
Okay. And you also indicated one of the things you do is train officers in Los Angeles. What kind of training do you do?
It's not just Los Angeles, it's all over the state of California. This course that I'm involved with is the only class of its kind in the country. And it's a class that is specific for hostage or crisis negotiators. And the course is called Domestic Violence for Crisis Negotiators. So I work with 3 retired lieutenants and 2 retired prosecutors from the state of California. And we go all over the state of California and work with usually between 25 and 35 hostage negotiators from a given area of California. And it's a 3-day class, and we kind of help them understand how the dynamics are so different with a domestic violence hostage or barricade incident than what they are with someone who's in a bank with a bag of money and wants to get away.
And how many years have you been doing that?
I've been working on the training the negotiators for the last 11 years, and I've been working with peace officers, standards, and training for 15.
And have you done any training here in North Carolina?
Mm-hmm. Yeah, I train law enforcement officers fairly regularly in North Carolina.
And so you actually work for law enforcement, defense, kind of anyone in the process, correct?
It's most often law enforcement.
Sorry.
Objection.
Sustained.
Your Honor, I would tender Ms. Gruelle as an expert in domestic violence and the responses to it.
Any objection?
Yes, the state does object, but doesn't wish to be heard any further.
All right. I'm going to allow the testimony to be received as proffered.
Okay. Now, Ms. Gruelle, to get to a little bit of the background, can you please explain to the jury some of the psychological dynamics of domestic violence? You know, what's different about it?
One of the things that you have to understand about domestic violence is that there's a lot more to it than physical and sexual abuse. There's coercion, there's intimidation, there's manipulation, there's oftentimes external pressures, and so when we start to think of domestic violence only as acts of physical violence, then we've missed a big part of the picture. And that's one of the difficulties is I think the general public oftentimes doesn't think that domestic violence is going on unless they can see physical signs like a black eye or a broken nose or a cracked jaw or something like that. But the reality of it is over all the years of working with as many victims of domestic violence as I have, there are numerous tactics that abusers use that go beyond the physical violence, that work to undermine the victim's sense of safety, undermine her sense of what's possible for her. And what happens as a result of those various tactics is the victims tend to self-isolate or isolate themselves inside their own minds and feel like they're afraid to reach out, they're afraid to tell anyone what's happening. Oftentimes when they do, they're met with judgment or scorn. What did you do to make him angry? If it was me, I'd leave. And so part of what we have to understand is that by the time there's black eyes and broken noses, a lot of other intimidating and coercive tactics have happened that have undermined her sense of self and her sense of what is right and wrong in a relationship.
Okay. What are some of the non-physical things that an abuser or that someone would do that would potentially lead to an abusive situation or be considered an abusive situation?
Threats to use violence, threats to hurt her, threats to hurt the children. He might threaten to report her to the authorities for some reason, like a drug charge or child abuse charge or whatever. Oftentimes, if he happens to be a person who has a prominent position in society, he presents a different face to the public, which makes it that much more difficult for her to get any kind of active consideration by the public because they've made their mind up about who they think he is. There's just, coercion, intimidation, using the children against her. There's just, I'll give you examples if you want concrete examples.
Why do victims tend to stay with abusers?
Oftentimes they stay with abusers because they think that's the safest thing for them to do, and that might seem counterintuitive. But the reality of it is a great number of women are murdered when they leave their abusers. In fact, that's one of the riskiest things for battered women to do. And while it might seem hyperbolic, the reality of it is a lot of women stay and learn to live with the violence rather than leave and run the risk of being killed. And the statistics bear that out.
Okay. As you do all this training, conferences, doing everything you do, what are some of the most, does the public seem to understand domestic violence?
I think the public thinks that domestic violence is unacceptable, but I think they don't understand the minutia, and they don't understand the other things that are at work that reinforce his abuse and control of her. And we as a society tend to be quick to blame the victim when she's abused rather than look at the offender and say, what makes you feel like you've got the right to control or intimidate her? She's a person, she's not your property. And I think we're not there yet. I think we've got a long ways to go before we really understand that piece of it.
And please explain a lot of this to the jury. Why do victims tend to stay with abusers and or go from abusive relationship to abusive relationship?
A lot of times what happens is the reason that domestic violence is so unique is that this violence is occurring in the name of love, in the name of family. It's different when two strangers get into a fight in a bar. One of them doesn't typically walk up to the other one when the fight's over with and say, gee, honey, I'm so sorry, I didn't mean to hurt you. But in domestic violence cases, that is what happens. There is a pattern of intimidation, then there's an escalation of violence, then there's an incident, and then, at least initially, oftentimes, it is followed up with apologies, promises to never do it again, promises to go to church or to go to AA or whatever. And women want to believe that the violence is going to stop, that he's going to change. It's just human nature that women want families to be attacked. That's just the way they want it to go. And so they tend to reconcile with the abuser. They might be afraid, for whatever reason, that they can't properly parent their children without the man in the residence. And then if he has successfully diminished how she thinks about herself and has gotten her to the point that she believes that she deserves the way she's being treated, then she tends to partner up again with someone who will treat her poorly because she doesn't believe that she deserved to be treated better than that. And it's sad because for those of us who are advocates, part of what we focus on is, for one thing, making sure that no violence happens ever under any circumstances. But number two, that victims start to understand and accept the value that they inherently have as human beings. Because when they do that, then they start to realize that they don't deserve to be poorly treated by their partner. And it ultimately is a win-win for everybody. The family's safer, the community's safer.
Is it common for victims to praise the abuser?
Yes.
And why is that?
Well, as much as I've worked with law enforcement over the years, I hear that victims will oftentimes take the witness stand on behalf of the abuser by the time the case goes to court. And a lot of that's self-preservation. I mean, if he has communicated to her that if he goes to jail, that when he gets out, it's going to be 10 times worse, then she's going to do anything and everything she can to try to prevent that 10 times worse incident or multiple incidents from happening. And so it is, it's a pretty significant ongoing threat that she lives with. And she learns to think about life in a way that those of us who don't live with an abuser every day don't think about it.
Okay. What are some of the typical responses that victims have? Actually, let's go to first. What is the cycle of violence? Are you familiar with that?
The cycle of violence is kind of what I mentioned a minute ago, where there's a tension building phase, and then there's an incident where there's physical assault or threat of physical assault, and then it's followed up with what was referred to as the honeymoon period, where he comes back and promises that he's never going to do it again, and he's so sorry, and he's going to, he's going to go to church or go to AA or whatever. And because this is a person that she believes she loves, she tends to believe that when he says he's going to change, that he's going to change. And I think that has happened with probably all the women that I've worked with over the years. They very much want the relationship to stay intact. They just want the violence to stop. And I think the cycle of violence and then the other issues that are related to that really speak to why this is such a unique type of crime. For one thing, the majority of the violence happens behind closed doors. And oftentimes abusers will present a very different face to the public, which again is a tactic. And I think we just have to be willing to see it for the bigger issue that it is. It's, as I said, it's not simply black eyes and broken noses. It's much more nuanced and much bigger than that.
Okay. And have you personally observed the cycle of violence and seen how it affects
Yes.
victims? And can you describe the steps of the cycle and then explain how victims react at each step?
Well, there's a Chatham County case in particular that I can think of involving a woman who had been married to her.
Sustained.
Okay.
Just more
General. Okay.
Not specific.
Abusers oftentimes are much more attentive early on in the relationship, much more loving, much more giving, much more seductive. They tend to make big promises, and women oftentimes report that they felt swept off their feet. And then when the controlling behavior starts, oftentimes women will think, well, this is just because he loves me so much. He's so jealous. He just wants me to be with him all the time. And sometimes they take that as a sign of affection. But then it starts to move into the more serious controlling behavior where he's starting to monitor who she's talking to and what time she leaves, to go to the store, what time she gets back, what time she goes to school to pick up the kids, what time she gets back, who she's talking to on the phone, who she's not talking to on the phone. And so, the brick wall sort of gradually gets built. And if she feels the desire to please him and to try to get the relationship back to that place that it was when they initially started seeing one another, then she might try to look away from the coercive acts or the intimidating acts or the controlling acts because she just wants to work so hard to try to get them back to that loving place. And that's just kind of the working definition of how these relationships play out.
And you had noted earlier that victims tend to minimize the violence they've experienced.
Mm-hmm.
How does that relate into the cycle of violence?
Well, I think part of it is, remember, this person is not a stranger to her. This person is someone that she partnered up with, someone that she feels affection for, that she feels love for, that perhaps she has children with. And so she's going to, as a form of self-preservation, say to herself and possibly to others, it's really not that bad. Or he was stressed at work, or I should have had the kids in bed at 8:30 at night when he said he wants them in bed. I mean, they start to get into self-blame as well. And so the minimizing, denying, and blaming comes from the abuser, but then it also comes from her. She starts to minimize, deny, and blame herself.
And once they start denying it and minimizing it, do they sometimes present, is it easy for them to relate the actual specific facts of what happened?
Objection.
Sustained.
Have you ever observed victims that have a hard time relating the actual events of what happened?
Yes.
Objection.
Sustained.
How many victims have you worked with over many years of career?
I'd say thousands. I mean, it'd be hard to put a number on it. Sometimes in the mid and late 80s here in Durham, we'd get 14, 15 crisis calls a day. So many.
Is one common feature of domestic violence jealousy?
Objection.
Sustained is to the form of the question.
What are some of the common triggers of a violent event in your experience?
Well, the one that I have seen most repeatedly is when the victim tries to separate from the abuser. He has done a variety of things to maintain the control that he feels entitled to with her. And then when she makes a move to separate away from him and from the violence, oftentimes that is met with extreme violence. So that's the thing that causes me as an advocate the most concern. And that's why we as advocates use what are called lethality assessments, because we know that when women are contemplating leaving their abuser, that the risk of potentially fatal violence goes up significantly. And so that's the thing one of the things that I look for most is she contemplating leaving or in the process of leaving. But another thing is this whole notion of what we refer to as morbid jealousy. And morbid jealousy is this idea of if I can't have you, no one can. You're my property. You're going to do what I tell you to do and when I tell you to do it. And you are not to, talk to the neighbors. You're not to talk to family members. You're not to talk to friends. And the woman ceases to become anything more to him than a piece of property, just like the couch or the television or whatever. And abusers tend to have a strong sense of entitlement, that she is his wife and those are his kids and he can manage them in whatever way he feels is proper, including using coercion, intimidation, and violence.
Okay. Are you familiar with the term post-traumatic stress disorder?
Yes, I am.
And can you explain what that is to the jury?
Objection.
Sustained.
How are you familiar with post-traumatic stress disorder?
Objection.
Sustained.
In this case, have you had an opportunity to talk with Ms. Mangum?
Yes, I have.
And what have you reviewed or what discussions have you had with Ms. Mangum?
I talked with Ms. Mangum about her history. I mean, it's been all things considered, it's been a brief period of time. I normally spend much more time working with someone. But we talked about her childhood and some of the issues in her childhood, and then we talked about some of the relationships that she's been in as an adult, and there is a pattern of being in abusive relationships.
How many times have you met with or interviewed Ms. Mangum?
I think at this point in time, we've probably met 5 or 6 times.
Okay. And have you also read the police reports in this case?
Yes, I have.
And your testimony here today is based on your experience, with your years of experience with battered women who come to you for assistance, correct?
Correct.
And then based on your conversations with Ms. Mangum. Is there anything, what if anything about Crystal's childhood stood out to you?
Objection, Your Honor.
Sustained is to form.
Okay. Is there anything about, okay, you just stated you believe that Crystal Mangum has been in a series of abusive relationships, correct?
Correct.
So, in your opinion, she's one of these individuals who goes essentially in a cycle of abusive relationships?
Objection.
Sustained.
Why do you believe that she's been in a series of abusive relationships?
Ms. Mangum disclosed to me early on in the interviews with her that she had been sexually abused as a child.
All right, members of the jury, I'm going to go ahead and call lunch recess for your benefit, and we'll resume at 2 o'clock. If you could recall the instructions, not talk among yourselves or with anyone else about the case. Don't form or express opinions about these matters. No media or independent investigation regarding these matters. Please have no conversations with parties, witnesses, or lawyers. Leave your notebooks in your chair, and at 2 o'clock we'll be ready for you. Everyone else, please remain seated. All right, Ms. Franks, what is the basis of your objection?
Your Honor, we object to what she got out and would ask that it be stricken, but the state would argue that she's not allowed to go into what Crystal told her about her past as far as sexual relationships or anything else as far as abuse. I do have a case on point, State versus Edwards, 174 NC App 490, if I may approach.
Yes, please.
The state has not asked for any basis of her opinion or anything of that nature from the defense attorney or from anything else. And in the State versus Edwards case, Dr. Hilke was called to testify as to his opinion. He was not allowed to get in anything that the defendant had told him as to the events or previous history of his childhood or anything else. However, he was able to give his opinion. The state does not object to the expert giving an opinion, but does object to her going into what Crystal has told her in reference to past sexual abuse history and things of that nature.
Mr. Meyer?
I'm just reviewing the case this second, Your Honor. I mean, I guess my question is they can testify without giving the reasons under Rule 705. You know, as she noted, the state didn't request the disclosure of those opinions. If they had, they certainly would. We certainly would have. In addition, I mean, this has actually been disclosed in her report. I mean, nothing that we're going into is not in Kit Gruel's report.
Your Honor, Rule 705, as mentioned in the Edwards case, is designed to allow an expert to give his opinion without, and we are asking that the court follow State versus Edwards and not allow her to testify as to what, if anything, Crystal may have told her substantively as far as sexual relationships or anything she may have said about what happened to her.
Well, and Your Honor, I would point out that if you read the case, it doesn't actually, I mean, ultimately it leaves it in your discretion. It says here, because the state did not choose to explore the basis for the opinions, the trial court was not required to allow the expert to testify as to those statements that form the basis. I mean, obviously, it would ultimately be in your discretion, but this is not a rule that bars her from being able to testify to it. It just says that since they didn't request it, you don't have to let them in.
And that is what the state is asking, Your Honor, that it not be allowed in.
So, as I understand it, what the state is asking is that the history that was recounted to her about childhood and prior relationships, you're suggesting that this expert not be allowed to recount that history that she relies on to form the basis of an opinion?
They should not be able to recount the history and what Crystal told her as far as to what she has been through or what she says has happened to her. And even to add to that, the defendant has also testified and has not said anything about that. But we would argue that that's not allowed to come in. She could say, based on her history, she's formed this, or based on the relationship she had with Milton Walker or this person, this, but to get into exactly what Crystal told her about each of these events, which would include that she was sexually abused, should not be allowed in.
Mr. Meyer?
I mean, I would just again argue it goes to the conversations, the interviews that our expert had to form these opinions. You know, Rule 705 is supposed to be a rule of inclusion. These rules and these statements, they were provided to the state. I mean, the state is pointing to a random blog that they've never verified saying, Crystal, you told people this. Isn't that a problem? And now we have an expert who's here to testify as to what Crystal told her to be cross-examined on it. Suddenly the state cares that Crystal told other people things. I would just argue, I mean, with Ms. Gruelle, this is what she does. She is an expert. This is what she based the opinion, and I think it's better to give the jury a more full story of this is why she thinks it, rather than have her say, this is why I think it, and then have the prosecutor in closing say, you know, she gave you a bunch of opinions but never told you why. How do you know why she had that? I mean, we're setting it up to where her opinions can be attacked because the jury is never going to know the basis for them, and for all they know, she just pulled them out of thin air.
Your Honor, in State versus Edwards, Dr. Hilke got up to testify during the evidence phase of the capital case. During that phase, the defense tried to get out everything the defendant told him, and that is what he formed his opinions on. That was the basis. The state during that objected. And Dr. Hilke was still able to testify that after conversations with the defendant, this is what conclusions he drew on each part of his life. So he was still able to give testimony. He just wasn't able to say what what the defendant had told him as far as his abuse as a child, his sexual abuse as a child, because he was claiming in this case that he had been sodomized as a child. And he was not allowed to get up there and say, I was told that he had been sodomized as a child. And he was not allowed to do that, but he was allowed to say because of his history, and I formed this opinion. And again, the state is asking that the court follow this case and not allowing that testimony.
Did the defendant testify in the Edwards case?
He did not. No, Your Honor.
I mean, we have two rules that are competing here. One is Rule 705 and 704, which allows the admission of the basis of an expert's opinions despite the fact that it may be hearsay. And then we have a hearsay rule that says that statements made by the defendant can only be offered against the defendant. So, and in this case, they're being offered on behalf of the defendant. If this were a situation where the defense was not testifying, I think we'd be in an entirely different category where perhaps through a back door there was some attempt to have statements made by the defendant introduced through an expert. That's an entirely different thing. So here we have a situation where the expert is saying this is the information that I use to form the basis of my opinion, and I think that generally should be allowed. There's an additional problem, and that is vouching for the credibility of the defendant, and that goes back to the analogy that I drew earlier of a expert testifying as to whether sexual abuse has occurred in typically child sexual abuse cases. And so I think it's one thing for this expert to say this is what was recounted to me, and to say that that would be typical of symptoms or consistent with symptoms of domestic abuse relationships. But I would caution that to the extent that this witness is offering some opinion as to whether those statements are true or whether the events that occurred on the night in question, April 3rd, 2011, are true. Again, that would be outside the scope of this witness's expertise.
And we're fine with the limiting instruction, similar to what you did with Milton Walker evidence.
Right. What I'd like to do is think about this a bit further, read this case, and think about the scope of the permitted testimony. And then there's also a Rule 403 issue that comes into play as well, that the opinion needs to be, that the basis of the opinion needs to be constrained to some extent by Rule 403. So those are all the factors I'm going to take into consideration. What I would, since we are going to take lunch recess now, it's just at 2 o'clock I'll come back down and tell you what my ruling is or hear from you first.
Yes.
All right. Anything further that we need to take up?
Well, I guess my only question is when we want to do the proffer with my other experts, if we want to do that after lunch, or have me just keep them standing around until we're ready for that.
How long do you anticipate that proffer? Are they going to just identify these?
The combined videos are all of 10 minutes, and I don't even know if we have to. I mean, we can certainly have him explain them and play them in probably 15 minutes, depending on how long it takes this thing to warm up.
Oh, you're talking about actually playing them in the courtroom?
I could certainly just have him describe them. I mean, this is more for the appellate records. I'm fine with that. If we want to put him on and have him admit the photographs, admit the videos, and explain what he did, so probably 5 minutes.
I think that the purpose of a proffer is just simply to preserve the nature and basis of your objection.
And that's fine with me, Your Honor. I can just, stick a sticker on it and...
Right, if you're just simply admitting it and his report, and then he can very briefly summarize the conclusions. If we can do that, say in 5 minutes.
Yeah, I think we probably can.
Let's do that. If you think it's going to be longer, then I'm going to need him to wait around until we have a longer break.
I don't anticipate it being any longer. Like you said, Your Honor, we'll just admit it.
All right,
and
let's get started.
Okay, let me go grab him real quick. Can I approach you for a sticker?
Your Honor, may Ms. Correll come off the stand?
Sorry about that.
Thank you.
Sitting up here.
All right.
Okay, and Your Honor, we would ask if Mr. Manning could take the stand.
Yes, sir. You'll come forward, sir.
Motion that doesn't have a raise your right, please. You solemnly swear that the testimony you may give before the case now being heard shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please have a seat.
Good afternoon, Mr. Manning. Can you go ahead and state your name and spell it for the record?
Yeah, Charles Richard Manning III.
Okay. And how are you currently employed, Mr. Manning?
I work at Accident Reconstruction Analysis Incorporated.
And what do you do?
I'm an engineer.
What kind of training do you have for your job?
I got my degrees at NC State University, and I've been working in the areas of failure analysis, accident reconstruction, forensic engineering for 35 years.
And where did you go to school? Where did you receive those degrees?
North Carolina State University.
And what kind of investigations and what is accident reconstruction?
We look at when something usually falls apart, reconstruct accidents.
Okay. And how do you conduct a reconstruction?
Well, you start with examining the physical evidence, and then from there you do analysis, potentially do testing, simulations to reconstruct.
And have you been qualified as an expert in North Carolina courts before?
Yes, sir.
About how many times have you testified?
In deposition, probably 50 or more. In court, I would say probably 20.
I'm sorry about that. Keep going.
Probably 20 times.
Okay. We would tender him as an expert in accident reconstruction.
All right, go ahead.
Did we ask you to do anything in this case? Were you retained by us?
Yes, you asked our firm to take a look at the failed door and tell you approximately how much force it would take to door in the fashion that it was seen in the photographs.
And when you did that, did you take several pictures and videos of that process?
Yes, sir.
And may I approach you on?
Yes.
Do you recognize what's been marked as Exhibit 1?
Yeah, it's a CD that contains the video of the testing that was performed.
As well as the photographs, your report, and resumes?
Yes, sir.
Is that in the same condition it was when you gave it to us?
I haven't looked at it, but I would assume it is.
Okay. Your Honor, we would ask to admit Defense Exhibit 1 for the purpose of the proffer, including the report, the photographs, everything contained on that desk.
All right, it's allowed for those purposes.
Okay. Thank you, Mr. Manning.
Thank you, sir. You may step down.
Thank you.
All right, thank you. I'll just note for the record that I don't know whether you saw admission of this report that was handed up as I was considering.
It was on the disc, and so I asked for everything that was on the disc, and that report is on here.
That's fine. So I'll note for the record that during my consideration of the objection raised by the state, I also reviewed what we'll mark as towards exhibit number 1, which is the accident reconstruction analysis Inc. report in this case.
Thank you, Your Honor.
Yes. All right, very good. All right, is there anything else we need to take up before we recess for lunch?
Not for the state, Your Honor.
Not for the defense, Your Honor.
All right, being recessed till 2 o'clock.
Supposed to be at 2 o'clock.
Okay.
Keith, as I was saying.
Okay.